Hi, welcome everyone. My name is Sang Kim. I'm a senior counsel attorney here at Visa Nation. Welcome to our open office hours Q&A webinar where we invite the attendees to post their questions here on chat live, and our team here will be happy to answer them. I'm joined here today by Shilpa Manik, managing attorney and partner, as well as Lindsay Sipp, associate attorney. Shilpa, Lindsay, like to say hello to everyone.
Hi, everyone. This is Shilpa Malik, the managing attorney at Visa Nation. We're here to answer your questions. So feel free to post away, and we'll try to get to as many of them as we can. And thank you for joining us today.
Thank you for joining us.
Thank you, everyone. So we hope everyone has been having a great 2024, enjoying the start of spring. This is our second Open Office Hours webinar. For those who are previous attendees or new attendees, just a reminder, this webinar presents an opportunity for people to post their questions here on chat live. Please go ahead wherever you're watching us, whether on LinkedIn, YouTube, or elsewhere, to begin posting comments and questions. We'll begin answering them. We want to advance a disclaimer that we are looking to answer generalized questions that will basically provide information to all the attendees. We would remind people not to provide very specific or confidential or privileged information regarding your question or situation. We instead welcome you to go to our website and our contact page and go ahead and schedule a consultation or contact us via email regarding, soliciting our legal team for further advice and assistance. So with that, I'm glad to see we have some starts to some questions. So I'm going to go ahead and remove our share screen here, move to group layout, and go ahead and start with our first question here. From Andrew. Thank you for your question, Andrew. I filed a J1 waiver and the status is pending. Should I file the I-130 or wait until I receive an answer from the State Department? It's actually a common question we get from our J1 applicants who are looking to change their status either via an immigrant visa petition or through a non-immigrant visa petition like an H-1B. So in this instance, and I'm going to invite Shilpa to add her comments in. It's going to be a little bit fact determinative, but we do find that filing the second benefits application, in this case an I-130, or in other cases an H-1B, the act of filing by itself, we found to be permissible, so long as you are transparent about the fact that you have J1 status, that you're subject to the 212E 2-year reform residency requirements, and that the waiver is pending. So in those circumstances, we often find that our clients are able to file both, and the final decision on the application acquiring benefits will continue to process until the waiver is completed. That's been most of my generalized observations. Shilpa, do you have anything you'd like to add or give a different viewpoint?
Absolutely. So, Andrew, it also depends on the kind of J1 waiver you're seeking. Is it based on a no objection waiver from your home country? Is it based on extreme hardship? Is it based on persecution? So, since there are different categories under which a person can apply for a waiver, the time to get a waiver can increase or decrease based on that. And essentially, what that really means is while there's no restriction on filing an I-130 while your J1 waiver application is pending, generally we don't recommend filing an I-485, which is the adjustment of status application, until you have received your waiver, because if USCIS ends up processing your I-485 before your waiver is approved, then they will end up denying the I-485 if you do not have the waiver in hand. But the I-130 by itself does not depend on the approval of a waiver. The 485 absolutely does. We do have some clients who do actually file a 485 while they're waiting for a no objection J1 waiver, but they're quite far along in the process and are just a few months away from getting that no objection waiver granted based on the circumstances that exist in their case. So this is our general advice. And of course, it's not a situation where one size fits all, and it will vary from case to case.
Thank you, Shilpa. Going to move on to the next question, also J1 related. It's a two-part question. I'll go ahead and start with the first one of what is our kind of observation of success regarding IGA waiver cases? And the second question is there a government department that has the most applications of IGA approved? These are pretty specific questions. I'm not sure we can answer either of them as far as statistical data that you're looking for. But I think my takeaway from this is going to be, and I'll turn this over to Shilpa as well for her kind of viewpoint on the IGA, Interested Government Agency waiver process, is if there is a bona fide IGA involvement and that is meets the requirements set forth by the State Department, then it's a presumed approvable case. As far as which IGAs agencies are better than others, I couldn't say. I don't think I have that data, and I don't think many legal teams have that data either. I think it's more about the fact that the State Department is pretty clear on which IGAs they will find bona fide for approvability. Anything outside of that will require kind of discretionary action. Shilpa, do you have anything you'd like to add?
Yeah, the most common ones that we see are the National Institute of Health. But that being said, it may not be applicable to an individual in every specific area of research or work that they're doing under a J1. So again, you have to be very careful about the governmental agency that you would be working with to get your IGA waiver process. Typically, you would know which entity you're going with based on the department that you're already working with and which has probably received funding from that interested governmental agency in order to further your research. So again, it's something that has to be determined on a case-by-case basis. But if they're done correctly and all the requisite documents are provided, then as long as you have the support of an interested governmental agency and you have the documentation proving that your research or the work that you're doing is critical to that agency, and you have recommendation letters and your employer's support, IGA waivers can definitely get approved.
Thank you, Shilpa. I'll also add we comment specifically about the National Institute of Health because many of our clients are medical and healthcare related and research, so that comes up. But that's not to say that is the only or best IGA. It's just simply what we've had visibility on recently. So I just want to make sure we've made that disclaimer. Thank you, Shilpa. Moving on to the next question here. I have a B1B2 visa. That is a tourist or business visitor visa. I haven't traveled yet, but I'm considering the option of getting a green card. I learned about EB2. Is that a good path towards citizenship without marriage? So this is a bit of a multi-part question. Shilpa, do you want to go ahead and just jump right into this as far as kind of taking this bit by bit?
Yeah, so a B1B2 is either a business or a B2 tourist visa, and coming to the United States on any of those visas gives you entry for approximately 6 months once you're let in. And there's no direct path to a green card from a B1B2. You need either an employer to sponsor your green card, or if you're in a relationship, in a bona fide relationship with a U.S. citizen, then yes, of course, you could potentially get married to the U.S. citizen and get your green card through that route. But your B1B2 has a limited life. It only allows you entry for 6 months, and there's no employment-based green card, perhaps other than an EB1A or an EB1 category green card that can be filed in that period for an employment-based through an employment-based sponsorship or a self-petition based on exceptional ability. When it comes to, or on the family side, it could be a marriage-based green card through a U.S. citizen. And this is a very open-ended question, so we are not able to tell you exactly what would be your best option. Your best basically, the best route that you could take is to consult with an immigration attorney, whether it's us or another immigration attorney that you choose to consult with, and share more details, personal details relating to your circumstance, and they'll be able to guide you to the best path forward.
Thanks, Shilpa. I just do also want to add that the B visas are a category of visa that is supposed to be non-immigrant intent. So we want to pursue that. You are looking at options, which you're welcome to do. You're looking to research, but entering in on a B1, B2 with the intention of filing a green card can be problematic. It is not. It is prohibited by the various federal agencies, as that is a wrong intent to enter the B visa. The assumption is that when you enter a B visa, you have at the time of entry the intent to depart the U.S. after your B1, B2, whether it's 6 months or less. Whether if you were to change your mind and circumstances arose that provided new information, then that is something you have to reassess at the time. But I would caution anyone entering on B, F, other sorts of visas where there is not an immigrant intent to be very careful about openly pursuing a green card action or an immigrant action at the time of your B1B2 visa entry. Moving on, I'll quickly answer this one regarding, is there a way to get a travel option if I have a temporary EAD based on hardship? So I would welcome you to look at the 131 advanced parole travel document. It may or may not be available to you based on the specifics of your hardship or what category you filed your EAD. But there is, I don't see, other than cost and time, I don't see much harm in trying to file for a 131. But it is a second application process you have to do. The EAD will only grant you work authorization in the U.S.
I did want to add something here, saying that as far as the travel option is concerned, it needs to be based on something. You either need to have an adjustment application pending, or you need to be here on temporary protected status. We do not have enough information to determine, well, how did you get your temporary EAD and what is your current status in the United States. A travel option may or may not be available to you depending on your current status in the United States and the basis on which you filed your EAD.
Absolutely. So again, just to refer back to the 131 form, that is the travel document component for, and that will give you the guidance and the instructions within the form itself to determine whether or not you are eligible. Thank you, Shilpa. Moving on to green card question, and Lindsay, I love your input on this one regarding a question from LS Moss. Is it faster or better to go through the National Interest Waiver or through an employer-sponsored EB2? For those in the call who aren't familiar with the NIW or the EB2, perhaps you can go ahead and start providing some background and your thoughts on this question.
Well, there's two different types of EB2s. There's the PERM, which is the employer-sponsored, and the NIW, the National Interest Waiver, which can be self-sponsored and not tied to an employer. The benefits of doing the National Interest Waiver are that it can be self-petitioned and not tied to an employer. It is typically faster. The PERM process can take up to about 2 years, whereas an NIW under regular processing can take about 6 to 8 months, sometimes closer to 12. But there is premium processing available for an extra $2,805 that will get your decision within 45 calendar days.
Yeah.
So
thank you, Lindsay.
NIW is faster and is not tied to an employer.
Yeah, most case bases, I would agree on that. To reconfirm, the reason why is, as Lindsay stated, is that the National Interest Waiver, by its nature, skips the PERM component, the labor certification process, and thus, where an employer-sponsored EB2, and we're making the presumption here, you are talking about the PERM labor certification EB2 PERM process for where you have to do a PERM first with the Department of Labor and then the I-140. The NIW is just the I-140 by itself. So yes, case for case, generally speaking, you're going to find that the NIW is going to process much quicker. Thank you for the question, and thank you, Lindsay. Moving on to the next question from Imra. Apologies for the mispronunciation. My I-140 application is on August 9th, 2023 regular when the possibility to be approved from USCIS. I'm a registered nurse from Albania. My application for Nebraska Service Center. So this is a bit fact specific. I'm not sure we can provide you specifically tailored to your question, but let me say that an I-140, generally speaking, is taking, from our visibility, about 6 to 12 months to process under regular processing. My assumption is that you are already on a valid visa status, or if you're outside the U.S., you will just need to wait for the I-140 to be approved and your priority to become current before moving on to the green card, unless you've already filed the green card based on that. But I would say is that your case is still within expected processing times, but you're welcome to contact USCIS and use either their chat feature or their 1-800 toll-free number to contact them to indicate that you believe the case is outside the processing times. And usually within 30 days, they'll either confirm that they've signaled the officer that your case is outside the processing times and they've brought it to their attention, or they'll confirm to you that based on the specifics of your case and where it is in the service center, it's still within processing times, and they'll basically ask you to wait another 30, 60 days before making another service level inquiry. Shilpa, is there anything you'd like to add to that?
No, I'm good. I think that covers it all.
Great, thank you. Moving on, what form will the employer file if they want to file a green card for its H-1B employee, and when can the employer start filing green card for its H-1B employee? This is going to be specific to the circumstances of the job offer, position, the employer, but I'm going to go ahead and assume it's the most common use case, which Lindsay touched upon before, which is the perm I-140 green card process from an employer-sponsored employee. Shilpa, do you want to kind of run through the three-step green card process for most of our H-1B clients?
Absolutely. So the three-stage green card process are the labor certification, the I-140, and the I-45. The labor certification process is done through the Department of Labor, and the Department of Labor prohibits employee involvement during that stage to maintain the integrity of the PERM process. The PERM process involves getting a prevailing wage for the position through the Department of Labor and placing ads towards recruiting potential U.S. employees who may be qualified for the position. And obviously setting the employer is expected to put the opportunity out in certain forms of job search engines and print ads, etc., so that U.S. employees or U.S. applicants have an opportunity to apply for the position. Once the recruitment phase is over, the PERM application is submitted to the U.S. Department of Labor. Currently, the U.S. Department of Labor is taking about 12 to 13 months to process a PERM application, and there's no expediting that process. Once the PERM is certified, the employer will submit what's called an I-140 petition to USCIS to get an immigrant visa number assigned to the employee. Now, depending upon the employee's country of birth, a priority date is assigned based on the date the PERM was filed. And eventually, when the I-140 is approved, that will become the priority date for that applicant. And based on whether it's an EB2 or an EB3, the priority date movement is dictated by the visa bulletin that is released every month by the Department of State. So now, if you were to be born in a country other than India or China, then you would expect to get on to the final stage, the I-45 stage of the process, either concurrently with the I-140 or within 6 to 12 months of the I-140 filing. Once the 485 is approved, that's when you become a green card holder. And of course, if you're from India or China, the processing times are much longer. I do want to point out that green card, the green card classification is based on the chargeability, rather, is based on a person's country of birth and has nothing to do with the passport that a person holds. So if you do happen to have a passport, let's say from Canada, but were born in India, that would make no difference to the time. You'll still end up waiting in the line that is for Indian applicants and not benefit from having a Canadian passport.
Thank you, Shilpa. I just want to add also to the question here regarding when can the employer start? They can start any time. I've had employers start the green card process on the first start date. I had green card employers start their process within X amount of days, weeks, or months or years within this employment. It's a conversation you're going to want to have with your employer. It's a benefits question. It's a question of whether or not they're willing to extend that much time, effort, and cost towards sponsoring you. As Shilpa mentioned, this is a very lengthy process. It's 3 steps. It could take some time. So this is quite a lot of time and effort on the part of both you and your employer. So having that conversation earlier than later is always a recommended idea, especially since you want to move further into your process for H-1B holders, especially before the end of your 6 years of validity time within the H-1B. As Shilpa mentioned, this process can take at least 2 years, if not closer to 3 and 4. So you want to be able to start this before your final 6th year of H-1B lapses. Moving on to a related question for a Masood, who's asking, as a Canadian, he's been living and working in the U.S. They or she or he been living working in the U.S. since 2007 on a NAFTA TN visa. Is there a way to get a green card? The answer is yes, there is, but it is particular to the fact that as a TN, that is a visa where you are not, it's not designed to pursue immigrant intent or a green card effort. However, there are ways to navigate that carefully. But conservatively speaking, many of our TN clients transition to H-1B and then pursue the green card process then. But if you are, you have the specifics regarding your employment, your position, and yourself, and you're flexible as far as not having to travel in and out of the U.S., that will present advantages towards pursuing the perm green card process that Shilpa mentioned. There are other types of green card categories available. Lindsay, would you kind of recite the usual three that for EB1s and EB2 national interest that also available outside the perm green card process?
Outside the perm green card, there's, as we mentioned a little bit ago, the National Interest Waiver, which is also an EB2. There are EB1 categories. There's EB1A for extraordinary ability. There's EB1B for that is sponsored by an employer for outstanding researchers or professors. But you can also be a researcher at a private company if they employ 3 or more researchers. And then there's the EB1C, which is a multinational manager, and you have to have worked overseas at the employer as well in a managerial capacity. But I would say EB1A, if the qualifications are met, and EB2 and IW are the most frequent paths for the employment-based green card.
Thank you, Lindsay.
Sorry, I would just like to interject here and advise that we have had several TN clients who have moved on to a green card directly while being on TN status. But as Sag rightly mentioned, there are certain, steps that need to be taken. For example, once your I-140 stage 2 has been approved and you're still on a TN, and you file an adjustment of status application, which is the I-45, then you can no longer travel outside the United States and re-enter the United States on a TN, because that is a non-immigrant visa status, whereas when you have submitted an I-45, you have indicated that you intend to become an immigrant in the United States and are seeking permanent residency. So we normally recommend that you have enough time on your TN left while you go through the green card process. And again, please do not forget that the chargeability is based on your country of birth and not based on your Canadian passport. So if you were not born in Canada but were born in a country other than Canada, be sure to check. If it's not India or China, then you'll fall under all other countries or rest of the world, as they call it, and your priority date will become current fairly soon. Usually within a year of the I-140 getting approved or being filed.
Thank you, Shilpa. So, generally speaking, I'm happy to say there is an option towards a yes, but the particulars and specifics are going to be necessary. I think at this point, it's going to do a quick check-in and, just offer our attendees here to note that you can always reach out to us here at our Contact Us page to book a consultation, or if you're an employer sponsor, to set up an introductory discussion or introduction with our legal team. Feel free to contact here, especially you'd like to follow up on something you raised here or heard about here on the webinar. I also want to point out that it is 23 after the hour. We will be ending our Q&A around 30 after the hour, 35. Thank you for the questions. We're so glad that the attendance and participation is robust and active. But if we are unable to answer your question, we apologize and hope that you contact us here or our website if you'd like to follow up with your specific question or concerns. With that, I'm going to move on to the next question here. I'm going to move a little bit faster. And so we won't be quite as detailed as we've been doing so, but thank you again for your time and effort. What are some basic requirements for a company to file an H-1B? I have a potential employer who's willing to sponsor H-1 for me, but they've never done it before, and I'll be their first H-1B candidate. Generally speaking, what the employer needs to be able to do is be able to file the requisite paperwork and essentially demonstrate that they are a bona fide employer with a bona fide position that is qualified for an H-1B. The H-1B is, generally speaking, is a position that by its nature requires a bachelor's degree in a specialty field, and that the employee has the requisite equivalency of that education. With regret to say is that if this is the first time, then you're probably going to need to wait till the lottery registration opens up again. It just closed this past Monday, so please check the USCIS news or our website to see if the next lottery registration opens up this year, or it may be next year until it opens again. The next question, is it legal to create a separate business account for collecting business profits and not touch your use at all? I'm on H-1B visa, wanting to start a business on the side. So I'm going to quickly answer this question, Shilpa, if that's okay. Generally speaking, H-1Bs are employer and position specific. So there is something we like to refer to as passive versus active income. So if it's passive income, meaning stocks, investments, generally speaking, that is permissible under H-1B status. However, if this is under business activity, meaning you are the CEO, the consultant, and there is active work engaged in it, then that is probably something you're going to need to file another H-1B or to investigate how to structure it so that way, it's within the regulations of the H-1B requirements. Again, this is a very specific question, but do want to note regarding that H-1B is required for any active employment, productive or otherwise, whether or not you receive compensation for it. In the follow-up question, how much time does an H-1B extension take? Generally speaking, a prep time for a case has taken our clients anywhere from 1 to 3 months to put together. Processing time at the service centers are fluctuating between 3 to 9 months, although premium processing is available, which will accelerate the processing to about 1 to 3 weeks or so. Next
Stein, I
question.
wanted to just take
Yes.
a question from Navina because I recognize her and she's been a past client of the firm. So hi, Navina. I hope you're doing well. Just wanted to say that, as far as your options are concerned, an H-1B always remains an option for you based on the facts that I am aware of. So unfortunately, the H-1B lottery period for this year is over, but you could technically apply again in 2025. But that would be the best visa possibility for you given the facts that exist in your case. And we've previously also discussed the potential of the company sponsoring you for a green card, and we're happy to take this conversation forward in an email should you want more information on that. But yes, H-1B or a green card are the paths that we would recommend for you.
Great. Thank you, Shilpa. Again, I'm going to kind of move quickly to this question regarding scheduling an interview sooner with the NVC and embassy. It's rather difficult. You can always contact the embassy and NVC, but unlike USCIS, there's no formal expedite process available. You're going to need to contact them and hope that they respond back to you regarding your expedite request. Moving forward, this is a fact-specific question, so we would recommend you take this question to our consultations. I am going to quickly screen through some questions. Welcome, Shilpa or Lindsay. If you have a question you'd like to take, let me know.
Okay, and I'll take Faraz Sayal, who asked about an E2 visa. Do legal costs count towards the initial investment? Any fees that you pay to an immigration attorney will not count towards the initial investment, but any cost that you incur towards setting up the business, engaging a business attorney when it comes to drafting the business documents, yes, you can utilize that towards the initial expenses, but not any fees that are paid to an immigration attorney to help you with the E2 visa application process. Now, in terms of approximate legal fees to help with the E2 visa application, we invite you to go to our website, which lists all our fees. One of our administrators will post a link to the fees section on our website. So please feel free to browse it and review the information on that web page.
Thanks, Shilpa. Are the current employment-based EADs taking more time than getting a green card? No, that's not been our experience. We find that the EADs are processing sooner than the green cards. But yes, it has been known to happen where the the green card is approved sooner because something happened with the EAD advanced parole processing and took longer. Again, I'm going to apologies for everyone who has asked very detailed specific questions regarding a case. Would welcome you to contact us for consultations on that. I'm going to basically go to as generalized questions as possible. If the employer can sponsor, what level of financial immigration requirement from the employer? Okay, so this is back to the H-1B again. The employer is obligated to pay the offered wages that meet the H-1B. That's the financial requirements. This is not the financial requirements that would be. It's not parallel to what's normally required as far as an affidavit support towards a a family-based sponsor. Let's see. Sorry, go ahead, Shilpa. You posted the E1 question you want to talk?
I was looking at Jill Spring's follow-up question. She said she did not get the 2 and 3 step process for the green card process. Jill, just for your benefit, the perm labor certification process is stage 1, which is step 1, and the I-140 immigrant visa petition is stage 2 once the perm is certified by the Department of Labor, and stage 3 is the I-485 filing if you're in the United States. If you're outside the U.S., then after the I-140 is approved by USCIS, it's sent to the National Visa Center for you to complete the final stage of the process, which is called immigrant visa processing through the National Visa Center. And thereafter, you'll be scheduled for an interview for an immigrant visa at the U.S. Embassy in your home country or your country of residence.
This question here regarding H-1B change the status to B. Some employees of H-1Bs who are laid off or termed will often have to transition to a different status. If they're running out of time, and then there's an opportunity to change back again. These questions you're going to need to refer back to the job offer and the employer and their legal team. If you don't have a legal team, feel free to contact us. We're happy to secure our services on that extent. But this is going to be a fact-specific question. But there is sometimes a path from going from H to B back to H-1B again.
There's a question from Javed Roshan. Is it legal to own a property on H-1B? Will it be possible to rent it out? Absolutely, Javed. Owning a property does not, basically qualify as employment. So you're not violating any terms of your H-1B. Yes, you are able to rent it out. As I tell all my clients who ask me similar questions, just the way you would invest in stocks for yourself and get a return on your investment, as long as you're not doing it for somebody else, you're not working in violation of your H-1B status, but feel free to buy property and rent it out and get rental income, because that's not considered compensation for work.
Thank you, Shilpa. There's a lot of questions here about the embassy and embassy, so I'm going to refer back to what I said before, is there is no formal expedite process for National Visa Center and embassy processing. You are regrettably somewhat at the mercy of both agencies, so I would contact the agency where your file is currently sitting, the embassy if it's still processing there, and the embassy directly regarding questions for expedite, changing approvals, or any other processing questions or you are undergoing. But regrettably, as you can look at the comments here, there's a much shared experience regarding the unsatisfactory level of processing and visibility and transparency that is going on with embassy and NBC. It will differ between embassy units, but unfortunately, Shilpa and I haven't been done this for quite a while. Some things don't change, and regrettably, because the embassies and NBCs are run under the Department of State instead of USCIS, the Department of Homeland Security, they have a different agency structure and, frankly, different goals and objectives. And regrettably, for lack of a better word, customer service is something to be desired and improved upon. We hope that you are able to navigate your situation positively. But regrettably, there isn't a quick fix solution for those. You're just going to have to keep leveraging the contacts, as limited as they are, at those for both those agencies regarding your specific case.
Sang, we're approaching 35 minutes. So I just wanted to remind our participants that we will be logging off in 5 minutes, and we'll try our best to get to a couple more questions. And we're really sorry if we haven't been able to get to your question. As you can understand, we try to do the best we can. by addressing as many questions as possible, but there will be a few that will remain unanswered due to the time running out. But please feel free to reach out to us either via consultation, or you can submit an online inquiry form, and we'll be happy to assist you in any way we can. And thank you for joining today.
Thank you. Let me see if there's any last minute questions I can answer.
I see a question from
okay.
Brahim. I'm sorry, I just wanted to go to that one.
Yeah.
It says, is there a way to expedite the visa issuance for my 11-year-old son? I applied as a green card holder. I would have to go back to what Sang said. The priority date for children of legal permanent residents is unfortunately not current, even though your son is a minor and is only 11 years old. Unfortunately, the National Visa Center or USCIS is not going to expedite your case, because there are hundreds and thousands of people who apply every year for a similar classification. They either apply for their children or they apply for their spouses. And it is just a 3 to 5 year wait period for you to be able to get your son to the United States under an immigrant visa as a legal permanent resident. Now, obviously, if you become a U.S. citizen in the interim, you can upgrade the petition by informing USCIS or the NVC, depending on where the application is, and then they may be able to process your application. In fact, they will be able to process your application faster and get your son scheduled for an interview sooner. But otherwise, there's no other way for them to issue the visa ASAP. Your son can try to get an F1 visa to come and study in the United States, but that again will be at the discretion of a consular officer if they do grant him an F1 visa while his I-130 is in line for the priority date to become current eventually.
Yeah, and I'm going to go ahead and share screen. Can we take down that question? Thank you. I'm going to share screen with our contact page again so we can close. And I'm going to give us some general, hopefully repeat something that might be helpful regarding, our time today, other than just simply contacting us regarding follow-up conversation for a consultation. For green card related questions, there are green card processes that allow you to file based on just yourself, so long as you qualify under one of the narrow strategies we've discussed today regarding extraordinary ability, outstanding research, national interest. They are high threshold evidence, so it does require quite a bit of work, but we find, it is a strategy we are successful with. For those who are seeking a green card through an employer or family, when and how you proceed on that is going to depend on whether you're outside the U.S. or inside the U.S. If you're inside the U.S., some statuses will allow you to convert and pursue the green card immediately. Others will require you to wait. Those are nuanced questions because, frankly, the green card and all the visa strategies require eligibility based on a number of data captures regarding your country of birth, country of nationality, what status you're in, your education, your background. These are multi-data point assessments. We regret we can't answer all of those today. Hopefully next time we will find an opportunity to, move to your questions quicker. But again, we welcome you to contact us directly on our contact us page for especially if you raise a question or a follow-up you'd like to have. With that, we want to close out and thank you all for your time today. We will be holding more of these office hour webinars throughout the year, so we hope to see you then. And we'll also be posting more specific contents regarding employment, family-based, and other generalized case strategy types. And please continue to subscribe to our LinkedIn page and our new our website. And we wish you the best in your strategies and efforts on behalf of yourself and your family and your coworkers. And thank you again for attending. And best to you all. And hope you all have a great year. And to those waiting for the lottery, fingers crossed. And we wish you all the best in your lottery selection process as well.
I do just wanted to close off by saying that, while we're here to answer your questions to the best of our ability and give you the best possible information that we can, this is not a substitute to consult with an immigration attorney and seek guidance based on the specific facts that you would be presenting to that attorney to assess your case properly. So please only take this advice as general advice. It may or may not be applicable to your case. We definitely hope that it's helpful to you, but if there's anything very specific in nature that you need responses to, please do make the time and effort to consult with a qualified immigration attorney. And with that, we wish you all the best, and we look forward to seeing you in future webinars. Thank you again.
Thank you.